Okay. Hi, everyone. Thank you so much for joining us this afternoon. I'm going to introduce myself first, and then I'll let Henry introduce himself. My name is Michelle Twall. I'm a staff attorney here at Houston Volunteer Lawyers. I've been here for about a year. Prior to this, I practiced in private practice, family and probate work for about 13 years. I saw a need for and a desire for coming into public legal interest law. So I made the change. Henry.
Yes. Hi, everybody. I'm Henry Sturm. I am I'm a pro bono fellow at Hutton Andrews Kurth, and in that role, I work with all the good folks at HVL, and I do probate cases here, and I also work on criminal expunctions and juvenile record sealings.
Today, we're going to go over settling small estates and how to handle chain of title property transfers outside of probate for the most part. Next slide. First, as an introduction, I'll go over what we do here at Houston Volunteer Lawyers. Our mission is to provide free legal services to the low-income population in Harris County. As referenced, there are nearly 4 million Texans living here below the federal poverty level. To meet this overwhelming need for legal services, we do this through the commitment of pro bono attorneys, hopefully like you. Each volunteer attorney who takes a case is partnered with a mentor staff attorney. For instance, if you take a family case, you may be with me or a couple other staff attorneys who practice family law. Probate, it may be myself or Henry. There are a few others of us. And we can bring to that mentorship some expertise that can help guide you through the process. Everything from answering any of your questions, document review, providing you with training and resources, templates, pleadings, all of that, so that you don't have to go through this process alone. And I know that could be particularly disconcerting if it's an area of law that you haven't practiced in or need to learn more about or want to learn more about. Next slide, please. To underscore the need for pro bono representation from our community, I wanted to show you that Texas ranks 43rd in access to legal aid attorneys. That means there's approximately one legal aid attorney for every 7,000 Texans who qualify for legal aid services. So there's a huge gap in the need of people who need services and then those who can provide them. Here at Houston Volunteer Lawyers, we serve clients who earn up to 200% of the federal poverty level. For a family of 4, for instance, that's $53,000 a year or somewhere around $4,400 a month. Our clients at HVL come with, different limitations that we may or may not have experienced in our own lives. For instance, some may or may not speak English. The majority have a more limited education base than some of the private clients that we may have worked with otherwise. Their sophistication with technology may not be as high. Their access to technology may be very different than from what you are used to. For instance, a client's cell phone may not be in service all the time, or they may not have a laptop and have to be reviewing all the documentation that you're sending them on their cell phone. But our goal is to help you meet the clients where they are and to work with them, on that level. Like I said, we're here at HVL, we're striving to bridge the gap between those who need representation and those who have the skills to provide it, like you. Some of the cases that we handle at HVL, you can see on this fancy pie chart that Henry put together for us. The majority of the clients who come in to do intakes with us are family law clients, custody, child support, divorce. The other big chunk comes from will and estate needs and housing needs. And those can be kind of, anywhere from eviction, landlord-tenant issues, but then also clients who need to establish a clear chain of title so that they can remain in stable housing. And this is because property has passed down from generations and it hasn't been properly cleared up. So that's what we want to talk to you about today. Next slide. Kind of a brief overview of what we're going to do today is go over generally intestate succession, what that means, what it means for a property to be an heir's property, and where that comes in. Then we'll give you some examples and tools that you can use to probate small estates, actually outside of probate, outside of the court. We'll go over some common myths that we typically hear clients, individuals say, some case examples to kind of fill in some of those myths, and you can see the cases that we may have available here. And then a little bit more about the impact that you can make serving as a pro bono volunteer and some of the resources that we have for you.
Okay, and I think that's my cue to start us off with some of the substantive discussion. So what we're dealing with today are people who are coming to us where there is no will or no estate planning in place for some loved one who has passed away. And this, as you probably, if you've practiced in probate at all, or if you remember from the bar exam or law school, this is known as intestate succession. And under the Texas Estates Code, the law tells us how is this person's property going to be distributed now that they've passed away and they didn't have a will. And when we're analyzing these cases to determine how that law is going to affect our client, we have to look not only at the relationship of the client to the decedent, but also have to look at the nature of the property. Is there community property, separate property? Because all those things are going to be distributed and dispersed amongst the heirs in different ways depending on who they are. Just as an example, a spouse is obviously going to have very high level, heirship rights to their deceased spouse's property. And children also are going to have those kinds of higher rights. And sometimes the spouse and the child can conflict if the child is not from that marriage. And so there's these different relationships between the heirs and the decedent that we have to look at to decide how is this going to be taken care of by intestate succession. And so sometimes we can do that without having to go to court. Sometimes you have to go to court. It kind of depends on the assets that you're trying to deal with, the size of the estate, and again, the people who are the heirs who are trying to settle this estate.
Can I add something, Henry?
Yes, please.
And for anybody who has additional interest in this, curious about intestate succession, Harris County Probate Court 1 has a great diagram on intestate succession, descent, and distribution in Texas that has really cool charts that you can follow and for all the different scenarios that can come up to help you figure out who gets what.
Yes, and I use that every day whenever I'm consulting with people, just to check back, okay, where does this go? Because it can get pretty confusing, especially the more heirs there are involved, figuring out what's going to go to who. And sometimes that means having a conversation with our clients to say, you're going to actually have only this percentage of ownership, or you may not get anything at all. So it's very important to do this at the early stages of, sort of the consultation with our clients and figure out, whether this person even has a claim to that estate and how we can help them. And so before we get into some of those processes about how we settle those estates, I wanted to touch briefly on heirs property, which is an issue that really affects a lot of low income and Black communities across the country and in Texas as well, especially the South. And this is where, as Michelle said, property is passed down over the generations, but it's never done through any formal probate process. So there isn't a clear marketable title. There isn't a clear chain of title, which means that they can't actually do much with that property. It can limit their ability to sell it, to remortgage it, refinance it, to do a lot of things. And that makes it a very limited resource, limited asset for them. And historically, unfortunately, what we've seen is we have these heirs property where there's, let's say 6 siblings who all have a right to their parents' house or their parents' land. And it used to be that, a buyer could come to just one of those siblings, buy a portion of the property, and then force a partition sale. And so it was something that was really upsetting generational wealth, which is often in houses and homesteads, and taking away those family homes that people had because they didn't have estate planning in place, which is not something that a lot of people have. I think there's something like, half of Americans don't have estate planning, and I'm sure a good portion of that are people from lower income communities who can't access legal services to get those wills properly executed. So fortunately, some of the laws around that are starting to change. In 2017, Texas adopted the, I think it's the Uniform Partition of Homestead, something like that, or Heirs Property Act, something like that. And it's a law that sort of limits that partition capability for, an unscrupulous buyer who comes in and tries to get it at a low cost. And it requires, multiple steps where even the court has to, consider sort of those cultural and familial factors of, what sort of sentimental value does this have to the heirs as well. So there are some changes in the law to get rid of sort of the inequities that are inherent in heirs property, but the consequences of that history are still affecting people, and they're affecting our clients. And so we have a lot of people coming to us who, have generations of unprobated estates that need to be taken care of so they can do what they need to do with their property, preserve their wealth, and make sure to pass it on to their family. And so that's a big portion of what we do with our probate cases here at HVL, is taking these intestate estates and figuring out how to preserve wealth for the person and preserve housing. So it's those are sort of the two prongs of it. And so to do that, with small estates particularly, and what we mean by small estates are, lower value estates or estates that are made up just of exempt assets, which would be like a homestead or, the one vehicle that a person owns, those kinds of things. These smaller estates, there's a few different ways that they can be probated. It's just a document signed, executed by some witnesses, and doesn't transfer title, but it does create a legal paper trail of how title should sort of pass down. There's also a lot of property taxes connected to this. A lot of our clients cannot afford, some of their bills, and often property taxes fall to the wayside. And the risk of that, of course, is that the county could sue on those taxes to then, take and sell the property to cover the debt. And so, figuring out how to make sure that the ownership is properly transferred in some way to this person allows them to access a few different ways to protect themselves from property tax debt. And then the third one is the small estate affidavit, which Michelle is going to talk about in a bit. And it does involve the probate court, but it's not the long, complex process that something like a determination of heirship would be. It's something that is, often done on a submission docket. Judge looks at it and signs it over. So it's a really great way for people to get that court order to transfer title without having to go through something long and complicated. So to talk about affidavit of heirships first, this is a big tool that we use for people. It is, just to go through these bullets, it operates outside of probate court. It what it is an affidavit stating the decedent's, name, where they lived, when they passed away, their family and marital history, the legal description of their homestead, all that kind of information. And then it's signed and notarized by two disinterested witnesses. And these are two people, of course, who have personal knowledge of the decedent and all that history that's in the affidavit, but they're not going to benefit from the estate. And so usually we're telling our applicants to get, friends, neighbors, coworkers, people at church, those kinds of persons to help out. And this can sometimes be a barrier if there's an older estate, someone who passed away, a grandmother who passed away a while ago, and there's no one alive anymore who really knew her besides family. And so that can create some issues as well. But if you're able to get past that, then it's a great way to create that legal paper trail of where title should go. It does not transfer title. And that's an important distinction to, inform our clients about, because it's not going to, if you get an affidavit of heirship, you're not going to be able to sell the property right away, at least not, getting title and insurance and all of that. Those title companies are going to want that affidavit to be on record for at least 5 years, at which point I think you could then sell it and get title insurance and all of that. But most of the people who we are advising to use this are not those who are wanting to sell right away. It's people who just want to have the house in their name and with the appraisal district so that they can take advantage of exemptions. Sometimes, if they're trying to access like Hurricane Harvey recovery programs, it's a way to prove that heirship interest so that you can access those recovery funds and get assistance repairing your home. So there's there's quite a few circumstances where an affidavit of heirship can make a huge difference. And it is a very, very easy document to draft and to execute. We've got, great templates for our volunteers to use. So it's really the work that goes into this for a volunteer is information gathering and then just guiding the person through the whole execution and filing process, because that can often be a barrier of its own, even if it's not exactly a legal, having to take legal knowledge, but it's how to navigate the legal system, which is sometimes the hardest part for people, at least at the beginning. And so we do a lot of affidavits of heirship, and we really value them. And so if you're interested in those, please get in touch after this and we can see about getting you set up to take one. And just sort of extending off of the affidavit of heirship is property tax issues. Like I said before, if someone is older, someone might be older or disabled and they can't afford their property taxes. And in fact, they might actually be eligible for certain homestead exemptions or even a tax deferral. And to sort of illustrate this, I'll just talk about a case I had where I had a man who came and he was an older gentleman, and he had lived in this home since he was a kid. It was his mother's home. She had purchased it back in the 70s or something like that. And she had never drafted any estate planning. So when she passed away, he was the heir, he was the sole heir, but he didn't have any formal documents establishing that fact. And he had property tax debt that came from when his mother was, still the owner of the house and wasn't able to pay. And now those taxes were under suit by the county. And, there was a great risk of them taking the house and selling it. And the real hardship of that for him was he had lived in this community his whole life. He was older, he was disabled, and he relied on the bonds he had with his neighbors to get to the grocery store. People would come by and check in on him. So there was a very important community there to his life and his survival, and taking that away because of this tax debt was just going to be such a huge amount of damage to him. And so what we were able to do is, he had a small estate affidavit, in fact, and we were able to use that to coordinate with the Harris County Appraisal District to get him a exemption on the property, so that, and we got him one for his disability, so the taxes would go down to about 0, I think. So the tax debt wouldn't be increasing anymore. And then we also got him a tax deferral, so that those unpaid taxes that he did have were not going to be due at that time. The lawsuit on the taxes was non-suited or dismissed because of the tax deferral, and my client is now able to keep living in that home until he passes away or decides to sell. And that gives him time to also figure out his own estate planning. What does he want to do about that tax debt? Who does he want this house to go to? So a really powerful way to help people preserve something so important as housing, and not just housing, but their family history and culture. And so being able to help him with that was it was very impactful for me. I know it was great for him as well. And honestly, it was not, these are very low risk, high reward types of cases. You are able to, talk to someone at HCAD to get an application through and file a few affidavits, and then bam, you're done, and the lawsuit is getting non-suited. So it's a great way to get your feet into the pro bono game, without really, especially if you're transactional, without having to require you do any hearings or anything like that. So I think it's a wonderful opportunity for all of you. And I think after that, Michelle will take over and talk about small estate affidavits.
So Henry mentioned this a little bit before. Small estate affidavits are another tool that you can use to administer and deal with a decedent's estate. The difference from an affidavit of heirship to a small estate affidavit is there is some court intervention when you use a small estate affidavit. It is very minimal. So we'll go over, for instance, let's start with when to use a small estate affidavit. You could only use one if the decedent did not have a will and there is no other pending heirship or probate going to occur. You would use a small estate affidavit also when you do not, there could be assets in the decedent's estate, but you do not need to administer them, meaning this is going to be a clear property will transfer from person A to person B versus having to sell assets throughout the pendency of a probate or something along those lines. So it's limited for less complex estates, but then also it's limited to estates that are valued at no more than $75,000 for non-exempt property. So you first look at the assets. A small estate affidavit can transfer a homestead, a decedent's homestead, to a surviving spouse, or if there are minor children involved. That is the only time that a small estate affidavit can be used to transfer property. If there is other property that needs to be transferred, say to somebody else other than a surviving spouse or minor child, then you won't be able to use the small estate affidavit. Then you can also look at, okay, what are your assets, homestead, but then also you can use it, for instance, to transfer vehicles. You can use it to transfer bank accounts, stocks, other tangible items. You can't use to transfer things like life insurance, annuities. Some of those items, for instance, those assets would generally be dictated by a beneficiary designation, but in some cases, the decedents haven't created a beneficiary designation, so then everything is just going to go to the person's estate. You will not be able to use a small estate affidavit to transfer things like a retirement, life insurance. But there is a pretty decent list of the assets that can be transferred with a small estate affidavit. So once you've determined, okay, do I have the right assets that can be transferred with a small estate affidavit, then you look to see, is the value of those assets less than $75,000? You do not include the homestead value if you're transferring that. You just look to your non-exempt assets, the bank accounts, the stocks, if there are any, cash, I guess there could be vehicles. Then you start the drafting portion of it. Harris County, Texas, actually every county there is a sample form that's used. It's on the Harris County Probate Court's websites that is very self-guided in helping you use it. It actually includes an affidavit of heirship, like Henry mentioned. And in the document, what you're basically telling the court is, Your Honor, this person passed away. This person left behind XYZ assets. This person and those assets need to be distributed to ABC persons. That's the small estate affidavit portion of it. And the distributees of the estate are going to sign the small estate affidavit portion of it and have it notarized. The second portion of it is the affidavit of heirship. And that is telling the court, yes, Your Honor, the people who signed the small estate affidavit are in fact the true heirs of the so-and-so decedent. I've known the decedent for 30 years. I was a neighbor, I was a friend, whomever. And they sign it with a notary. That all gets filed together with a proposed order to the court. And it's heard by the court on submission. There generally hearings are not required for small estate affidavits. And in the end, the court signs off on your order, and that order simply states, yes, we agree with the small estate affidavit, everything in it. The court agrees and approves that everything, all the property that's listed, goes to the distributees that are listed. If an applicant through HVL files together with that small estate affidavit a statement of inability, all of the court costs will be waived. The filing fees, it's around $300 or so to file a small estate affidavit. So making sure to file your pauper's oath or your statement of inability is very important for our clients. And then typically Harris County courts, say you're going to be transferring a homestead, they will record the order approving the small estate affidavit with the property records, the real property records. So that's a little bit of a fee savings to the client. And then it also transfers property. It transfers chain of title from a surviving spouse, from a decedent to a surviving spouse, which can be very helpful. A big or an issue that can prevent a small estate affidavit from being approved by the court is if, for instance, on the account, say a bank account doesn't list a value or says unknown or doesn't have a bank account number. All that information has to be included in the small estate affidavit. So it's very clear what needs to be transferred, and who is it being transferred to. Oftentimes clients will come to us and not know all of those details. The probate code or Texas State's code provides for this and actually has provisions for a motion to access bank records that can be filed in order to get access, for the applicant to get access to that information to then be added to a small estate affidavit. Did I miss anything else?
I think you covered it. And I mean, I think we have a lot of people who come to us, maybe not a lot, but I've had people come to us who have already filed a small estate affidavit or affidavits of heirship, and they've done it wrong, so it's not actually going to work. If they've filed the small estate affidavit without us, they've probably paid the filing fees, which I think can be around $300. And so, sometimes people are coming to us and we're having to tell them how to actually probate their estate. And I think that just points to the importance of, building on community education around estate planning and probate so that we can help people, take more autonomy and control of how their property is being passed down and taken care of. And these are great ways to do that, so long as they know what they're doing or they have legal representation, which is where y'all come in.
Okay, next slide. So often on calls, or you'll hear from individuals, some of these kind of little quips about, well, my husband passed away, so the house is automatically mine, right? I can do whatever I want with it. That's not exactly how it works. Theoretically, yes, if it's community property and there are no other children from outside of the relationship, then yes, I mean, it is yours based on community property laws, but it doesn't magically transfer. So that's when we walk them through, for instance, so you'll need a small estate affidavit, or if that's not applicable, then you'll need an affidavit of heirship. I recently had an individual where spouse passed away. He left, a decedent passed away. He left a wife, 3 children from that marriage, but then also 3 children from a previous marriage, and had to realistically explain to the client that, while I understand this has been, your house with your husband alone for all these years, his community property interest actually goes 50% to all of his children. So luckily, the adult children from the previous relationship were more than willing to, sign over any interest they have to the surviving spouse. So that really worked out for her. But that was a kind of come to terms, realistic talk that, we had to have, because she thought, oh, no problem, this is my house. So another one, for instance, that like what Henry was talking about, if I pay the property taxes, I get to own the property outright. Well, again, it's not that cut and dry. You may have a claim, from the estate. And oftentimes, for instance, you'll see HCAD will even have who is technically not the legal owner's name of the property listed on the property, because you just fill out a form through them to do that sometimes, but that's not actually legal title. The person wouldn't be able to sell the property, in those cases. Any other tidbits, Henry?
Yeah, I think, the last one, I can sell my loved one's property without going to court. I think I see that the most with vehicles and people doing, person-to-person sales, like via Craigslist or wherever, and, selling something without having title. And so they're not transferring title. And then our applicants are coming to us saying, I think that was my car. And we can say, yeah, actually, according to intestate succession laws, it would go to you. If that's happening, I mean, some of these can get a little, family can be tough, and in the probate context, and there's money and stuff like that. I think it can get a little heated or a little, just a little messy. And so our job is just to help them better understand how the process is actually going to work under the law, so that they can, protect whatever rights they do have. And I, in my experience, once you do have that discussion with people and sort of give them the definitions and sort of the step-by-step how things work, most of them understand it and then can, are really great sort of collaborators and team players on taking care of their own probate process. So, there are all these myths of what they come to us with, but I would say that our clients end up being really great people to work with, and who are, more than willing to do what they need to support you as the attorney, taking care of their loved one's estate. So all of this is just to say that there's conversations to keep having with them about how the law works, but I think those can be actually pretty enjoyable conversations and enlightening conversations.
I would say definitely, and with the ease of using an affidavit of heirship or a small estate affidavit, once you kind of explain how those processes are pretty simple, to the clients, they understand it and they gather all the information that you need. And for the most part, I know generally for my cases, before I will put a case out for, potential pro bono attorney to take, I've made sure that my clients have given me the witness names, the property descriptions, all of that, information that we'll need before it comes to you.
Yeah, we do a significant amount of vetting so that these cases are worthwhile for y'all, so that your pro bono hours are going to something useful. And that's probably a good segue for us to talk a bit about, and Michelle touched on this earlier, but just to talk a bit about what you get when you do volunteer with us.
Exactly. I mentioned a little bit before about once you take a case and knowing that an applicant comes, to Houston Volunteer Lawyers, they go through our intake process. They are then paired with a staff attorney in a clinic. And it's in that clinic, in that consult, that the staff attorney will vet the case, and the client will, be the first one to go over any documentation involved in the case, to request all the required documents, for a case to move forward. And it's not until all of those kind of boxes are checked that then a client, their situation, their case is put on our website, or we try to place it with one of you lovely volunteer attorneys to take with it, for us and help us. So knowing that you're getting a case that's already kind of teed up a little bit, just know that. As part of the process, we hope to provide, these CLEs that are informative. You do have a mentor attorney who is generally trained, practice experienced in the area of law that they're going to mentor you on. You can come to them with questions of any sort, pleading, I'm having trouble reaching my client, you name it. We're happy to help with any of that. And then at the end of the day, you may have learned something outside of your general practice area, develop new skills. Like if you take a case, for instance, that requires some court interventions, a court appearance, now you've got that under your belt. And you've been able to do it guided through, with an attorney who can help you, a mentor attorney.
Yeah, and I'll also add that we've got, in addition to this sort of webinar today, we have CLEs that really dive into the substantive elements of these different things and break it down for y'all. So, you take these cases, we have a lot of resources to give you so that you don't ever feel like you're just being, put out on your own to figure it out, because that's not the goal. The goal is, for you to serve your client and make a difference, but also for you to have a good experience, so that we don't want you to waste your time on something that's not going to be worthwhile. And so we do our best to bring all of this together so that you're benefiting from this as well as your client. And with that, that is sort of our discussion today about settling small estates. Here's information for getting in touch with us. You've got Michelle's contact info and mine. I've also put Ann Chandler's up there. She's our executive director. And then Brittany Crona is our pro bono coordinator, and she does a lot of the work of, helping people get set up on cases and working with firms to, coordinate projects and all kinds of things that really help the organization run. So you are free to get in touch with any of us to ask about cases that you can take, or if you do have a case, to ask for help. That's what we're here for, is to help you and support you. And so we hope that you do reach out, and we hope that you do want to take a case. We've got plenty for y'all to take. As an example, I've got one where a person was a spouse of a veteran, and he passed away, and now she's trying to, transfer title of their homestead into her name. And so there's, just really impactful stories that you can be a part of.
I have a couple of examples. I spoke to a woman who is a surviving spouse of an individual who passed away from COVID, fairly young. He left behind 2 minor children. The decedent had established bank accounts for both of his minor children, working hard to do that. The mother, surviving spouse, she was able to secure access to the bank account for the older teen child. I believe that child was 16. So the court felt more comfortable with the mom accessing, or I'm sorry, the bank felt more comfortable with the mom accessing that account. But then there was also an either 8 or 10-year-old son who the bank will not, I believe it's Bank of America, will not allow mom to have access to this account. So this is a perfect example of a small estate affidavit when it can be used. The mom has all the witnesses available. She has the bank account information. She knows the valuation. And then, either she can be named the custodian of this account, or if the court is not comfortable with that, the court will require that these funds go into the registry of the court until the child turns 18, after their 18th birthday. So that's a great example of, using a small out-of-state affidavit, basically helping her fill out the form and get it before a judge so that she can make sure that, her husband's, hard work doesn't go to Texas exempt property, Texas lost property or whatever, so the family can use it.
Yes, I think that's really valuable. And I think it's also just indicative of, sort of, these are simpler cases, but I think you do learn a lot substantively, and there's always, unique turns of a case, and, whether you're dealing with minor children or stuff, there's always going to be stuff to learn. So, as legal professionals, I think it is intellectually challenging in a way that is enjoyable for us.
But I've actually have another case that could fit in a affidavit of heirship situation. It is the applicant who approached us is currently a college student. Her mother passed away, leaving 2 young adult children, left a home, and the decedent was in the process of getting funding from the government land office to repair some Harvey damage. The home is in very bad shape, mold, all kinds of things, but the government land office GLOW will not continue with the repairs until this applicant and her brother can show that they are now the rightful owners of the house. So just having, and GLOW will accept an affidavit of heirship. So just having that completed and on file with the property records will allow this family to continue forward. We've got a couple of questions.
Wonderful.
Okay. The first from LaShawn, what about the transfer upon death deed?
So that is more on the estate planning side of it. It is something we use with our probate clients, but that's for a person to settle or to distribute their own estate. And it's just a deed that says, when I die, this property is going to go to this person, and you file it in the real property records. And then once you do pass away, the heir, or whoever's, the person who's the deed is transferring the property to, files an affidavit of death in those records, and then you've got that clear chain of title of where the title is going. And that's also really great for our clients because it avoids the Medicaid estate recovery program, which I won't get into too much because that's pretty in the weeds. But if you have Medicaid, which a lot of our clients do when they're older, the state can take out of your estate to pay back whatever you used for Medicaid. And so, but that only happens when you go through probate court. So this kind of outside of probate process sort of preserves that wealth for you and your family.
Next question from Carol. On a small estate affidavit, who is responsible for making sure the debts shown on the affidavit are paid? That's a great question. And I'm sorry, I didn't cover that. Also, to use a small estate affidavit, you have to ensure that the estate is solvent. So the debts cannot be more than the assets that you were listing. So, but what typically happens is that the distributees on the estate affidavit are technically, constructively, the ones who are now responsible for the debt. It is not very often that the creditors go after those distributees in a lot of the cases, but that's how that technically works. Those individuals would be the next in line to be responsible for the debt.
And then for Carol's next question about retirement accounts not being listed on the small estate affidavit, and particularly those where there's no beneficiary, how is that taken care of? Does it have to go through probate? I actually had a case like this recently. Most retirement accounts are going to, if you don't designate your beneficiary, I believe most of them will have sort of a default beneficiary provision. And oftentimes that's going to be going to the spouse or the minor children or potentially adult children. And that can get complicated. But if you are a spouse, then I believe all you have to prove to the company that has the retirement account, the bank, is that you are the legal spouse. In my case, the wrinkle was that they were common law spouses and they had never done any sort of formalization of that, but they did pay taxes together, own the house together, all kinds of stuff that proved it. So we used a small estate affidavit to sort of certify that marital status under a probate order. And then that was provided to the bank for the spouse to be able to access an IRA. So it depends a bit on, who your client is, who's trying to access those funds. Like Michelle brought up about minor children and minor accounts. If it's minor children, then you probably will need to go to probate court to set up, put it into the court registry or different things like that. So it is contextual, but hopefully people are designating beneficiaries so it just operates as a contract. Michelle, do you have anything to add on that one?
No, exactly. I think you touched the nail on the head, and it was really cool to hear your specific situation and how you helped the client, figure out, a relatively easy process to go through to get it. It seems, in my experience, that it really just depends on the terms of the contract. That that for the IRA, for the 401k, whatever it is, and what the terms provide, for who it goes to in the case that there's not a beneficiary designation. I believe if there is, in some cases, if there isn't one and it just goes to the estate, then you may have to then go through an heirship, but it's just really going to vary. I think there has been a push. I was reading a bit that some plans or administrators of plans were talking to their, I guess, different institutions about the rise of small estate affidavits, because they're throughout the country, they're used in all different states. And so I think some plans will accept them. I spoke to an individual the other day. Her deceased father worked for an elevator company of some sort, and they told her, hey, we'll accept a small estate affidavit. So it really depends on the circumstances for each case, I think. Yeah. What happens when an heir inherits a home from a parent who previously had a senior tax deferral? Is there a large tax debt? How does the heir sell the home if they cannot pay the tax debt? Yeah, so with tax deferrals, when the person passes away, I think there is like a 180-day period from when HCAT is notified of the death that the tax deferral sort of is supposed to go away, and then at that time, I think that the county might be able to collect on that debt, or sue on the debt, or what have you. I think a lot of people who inherit this kind of property don't know that they're supposed to tell HCAD. And so sometimes it's 3 years later and they come to us and there's this tax deferral. And I believe that the law states that up to 5 years of back taxes can be collected. So it definitely creates a tough situation for people, which, as this question indicates, makes the likely solution to be selling the home to cover that debt. But to be able to sell the property, you're going to need to, depending on depending on the parties and all that, you would need a court order to actually transfer title, small estate affidavit. If you can't do that, then a determination of heirship and request for letters of administration. We'll actually have a CLE on that topic. September the 1st, I believe. Mm-hmm. Stay tuned for more. Yeah, so we can get into the weeds of that a bit more, which, it gets a little, we're just getting more involved with court there, so it's a different situation. Exactly. Our last question is from Megan. Do you anticipate the limit of $75,000 on small estates increasing in the next few years, given the increased cost of assets? It would make sense to me. I believe it used to be, I do believe it used to be $50,000. And I don't know exactly when that was changed. I want to say though that was changed only in the last handful of years. So maybe in the next 5 years, we'll see an increase to 100,000.
Yeah. Yeah, I mean, it definitely makes sense. The good thing is that homesteads are exempt. So at least for our clients, they've got a homestead, they've got one car, those things aren't calculated into it. So really, when we're looking at the assets, it's $5,000 in a checking account, and that's mainly what goes into that calculation. But this is a legislative issue, and so I think it's a question of whether legislature is going to want to act on that and make those changes. I know we had recently the state, made some changes to exemptions and deferrals and limiting how much property taxes people had to pay. So I think there's an interest within the state legislature toward preserving property ownership. I don't know for certain, but that might be, maybe Megan, maybe you need to spearhead that reform effort to sort of increase that limit.
Okay.
I'll stop sharing. And were there any more questions that anyone had? We're happy to chat. We are recording this, so we'll circulate it to you if you've attended or if you signed up to attend, so that you can rewatch it, look at the slides, and get in touch with us. Our website is makejusticehappen.org, and you can always go there to learn more about how we operate and to get in touch with us. For those of you who did not get to write down our emails when I had that slide up, I'm just going to put it in the chat. And Michelle, you want to share yours as well?
My email, yes.
Yeah. Just in case y'all didn't get it down. And yeah, we would love to hear from you. We've got cases, we've got more CLEs upcoming, so please get in touch and consider taking a pro bono probate case.
I did it. Okay, good.
Okay. Wonderful. Well, I think that brings an end to our presentation. Thank you, Michelle, and thank you all for joining us today.
Thank you so much, everyone. Please reach out with any questions. If any of the cases that we talked about interest you, if you just have any general questions about probate, happy to help.
All right. Bye now.